a certified true copy of the appeal court judgment on Kano State governorship election has affirmed the victory of Abba Yusuf as the duly elected governor. As indicated in the written judgment, the Court of Appeals set aside the judgment of the Kano Election Petition Tribunal for lacking in merit. In the evidence contained in page 67 of the copy of the appeal court judgment released on Tuesday, signed by the registrar, Jamil Ibrahim Umar, the appellate court upheld the victory of Abba Kabiru Yusuf of the New Nigeria People's Party, NNPP. Addressing journalists on Tuesday evening, the Kano State Attorney General and Commissioner for Justice, Haruna Dediri, said page 67 of the certified true copy of the judgment clearly indicated that the tribunal's ruling that sacked Governor Yusuf was set aside. Barrister Dediri insisted that contrary to what the judges read to the public in the courtroom on 17th November, the written evidence has vindicated Yusuf as a legitimate governor of Kano State. Joining us now on the morning show is Ladipo Johnson, spokesperson, New Nigeria People's Party. Good morning, Ladipo Johnson. Thank you very much for joining us.
Good morning. Thanks for having me.
Well, what is this confusion all about? I mean, the newspapers, the media, don't let me say the newspapers, reported that the Court of Appeal sitting in Abuja affirmed the ruling of the tribunal in the Kano governorship election. What the tribunal did was to sack Governor Abba Yusuf. And now we're being told in the certified true copy that by the interpretation of the Dediri of Kano State and by the interpretation of Femi Falana SAN, which we have seen in the papers yesterday, it was on one of our programs yesterday, he too is saying that contrary to general belief that what the court did was in fact to affirm the victory of NNPP Governor Abba Yusuf of Kano State. What is the source of this confusion? Where do you think this could easily have come from? How could judgment read in open court be different from the certified true copy, which, by the way, wasn't released until 5 days later, only yesterday, 5 days after the ruling? Over to you.
Thank you. Thank you very much. It is very unfortunate that we have come to this low state in the country regarding the judiciary. I am a legal practitioner, and it hurts me, it pains the heart that this is the sort of situation we find ourselves in. As you rightly said, what was read out to the entire world last week Friday is different from what we've seen in the certified true copy that was finally released yesterday. Because, you know, you just have a 14-day window to lodge your appeal at the Supreme Court. And so when you deliver judgment on Friday and you do not give, in an election matter, you don't give the certified true copy to counsel till some 5 days later, it really makes no sense. And you begin to wonder what is going on. And as Chief Falana said on his program with Charles, it was what is going on? We don't understand it. But whatever it is, it shows that this is scandalous. It's a scandalous judicial debacle that we're facing with what happened in the Court of Appeal.
Okay.
Now, I'm not part of the legal team. Yes, you were about to say something.
No, go ahead, Mr. Johnson. Go ahead, just finish up before I read something to you. Just go ahead.
Yes. Yes, I am not part of the legal team. I don't know which way they're going to go with it. or well, I know the appeal originally was going to the Supreme Court. But from a political perspective, the optics are very bad for the Court of Appeal and for the Nigerian judiciary, unfortunately, at the moment. Okay. You were going to read something, sir.
Yes, I was going to read something. That page 67. Let me take it from the last part of 66. Yes. It says, from the fact of the case, I'm tempted to think and say that within the collective conscience of the appellant and the third respondent, that they know the truth of the matter. And I'm reminded of those indelible evergreen words credited to the highly revered sage, Uthman Danfodio, that says, conscience like an open wound and only the truth can heal it. I'll say no more. And it goes further to say, I will conclude by stating that the live issues in this appeal are hereby resolved in favor of the first respondent against the appellant. It now goes again by saying, in the circumstances, I resolve all the issues in favor of the appellant against the first respondent. Therefore, I find no merit in this appeal, which is liable to be and is hereby dismissed. The judgment of the tribunal in petition number blah, 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 between All Progressive Congress and INEC, blah, 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 was delivered on the 20th day of September. The sum of 1 million is hereby awarded as cause in favor of the appellant against the first respondent. I see a lot of contradictions in there. Please, I don't get it. I'm very lay when it comes to issues like this.
Yes, Rufai, you've put first paragraph for the respondent, second for the respondent, third for the petitioner, but the concluding bit, when you said the judgment of September, whatever the date was, in the tribunal, you didn't finish the quotation, is hereby set aside. Now, what this is, I tell you, is so sad. I was on, as you know, social media all night. And one of the commentators was saying that it is clear that if we take that what they read was what they read on Friday, then it is clear that the average man, from looking at the certified true copy, would believe that there was an earlier judgment and that later, for some reason or the other, it was changed. And in this modern age of cutting and pasting, when you have your document in Word and you don't want to retype everything, they made a mistake or they left that core part, that conclusive part, that the tribunal judgment had been set aside, was left there.
Wow, this is a big indictment.
So it begs the question. Everyone's asking.
Are you sure of this? I say, are you sure of this position? Because this is a big indictment on the judiciary.
Look,
are you sure this is your position? Yes, sir. Go ahead.
I am saying that. Hang on, sir. I said I put the average man test. Show this to anyone, Rufai. Those last 2 pages, to page 67, and they'll tell you, okay, it's contradictory. What could have happened? You would never have seen that the tribunal judgment was set aside and it's in favor of the petitioner if there was no written document to that effect in the first place.
So in the first paragraph...
That is why I'm saying, of course, I wasn't there with them. That is why I'm saying that the average man test will get you to that conclusion.
So hang on a minute. In the first paragraph, it said, I will conclude by stating that the life issues in this appeal are resolved in favor of the first respondent and against the appellant. Then he now went further to say, in the circumstances, I resolve that the issues are in favor of the appellant against the first respondent. Which one are we to believe what's going on here?
Okay, just hold on. I think the issue here... hello, can you hold on, Ladiko Johnson?
It's a riddle in a mystery and an enigma.
Can you hold on?
Yes, sir.
I think, we have to go with Femi Falana SAN's recommendation. That some of these Court of Appeal decisions will have to be reviewed by the Supreme Court. The Supreme Court is a final place. Because when you look at the other 2 justices who were on that panel, you will see that Bitrus Sanga, JCA, more or less concord with the lead judgment by Justice Adumain.
Yes.
Okay? But when you go to the submission by Latif Ganiyu, JCA, you see a difference there.
Yes.
Latif Ganiyu, JCA,
Yes.
is saying, I'm of solemn view that this appeal is liable to be and is hereby dismissed. I abide with the consequential order as to cost. So you see the third judge dismissed the appeal. 2 agreed. So I think the basic thing is that the Supreme Court will help us shed light on this matter. But it's not only about INEC votes.
Definitely.
INEC not stamping ballot papers. There was another issue
the
raised.
ballots, yes.
There was another issue raised here. I've not read the certified true copy. I'm just looking at the ratio towards the end because this is about 72 pages. It will take some time to read it. But I just went straight to the ratio. Now, there was another issue that their lawsuits raised, Section 134 and Section 177, which they said the tribunal did not address. That Abba Yusuf was not in fact qualified in the first place to be a candidate of the NNPP because his name was not in the party register. And at the party register, the Electoral Act requires that your name must be in the party register at least 180 days before election. And that Abba Yusuf was not even a member of the NNPP. And that the rule is that you must be validly nominated by a political party for you to run for election as a candidate. There is that other matter that is there, that the Supreme Court will have to look into. So I don't think this matter is over yet, and I don't think that the NNPP should be jubilating. We just got the certified true copy yesterday, so I'm not sure. I'm not sure your lawyers have had enough time to study it.
On the contrary, sir, it's not a sense of jubilation. It's a sense of sadness that the judiciary has brought us to this stage that we're in now, or that we're at. And the issue is not just for the Supreme Court to review the judgment, but the NJC must thoroughly investigate what has happened. If need be, they might need to use an independent investigator. It is so sad that we have gotten to this stage. How could you have such a conflicting thing at the Court of Appeal? So the issues that the issue of membership or whatever, that will be treated at the Supreme Court. But it remains that, INEC has a new way. You have to upload membership. You have to upload your candidates. And if you do not upload membership cards, etc., you are not, the full thing it won't go through. So I was not at the tribunal. As I said, I didn't participate in the legal sense at the trial or at the Court of Appeal. So those will be details to be handled by our team. But we are confident that if we have, unfortunately I'm saying that, if we have an unbiased panel, then justice will be done for the millions of people in Kanu who do not understand all these technicalities. All they know is that they're being cheated. And it is unfortunate that that is where we're at.
Okay. So, because, we just got the judgment this morning, so reading it is, it will take some time, like Dr. Abati said. I would also like to ask you
yes.
On this. The commissioner, I think, for justice in Kanu also muted what Mr. Falano was saying about this discrepancy. Is it based on this now that what will the NNPP be seeking at the Supreme Court now? Because, so that's where the conundrum, hang on a minute, that's where the conundrum starts. Because what are you even now taking to the Supreme Court? If the Court of Appeal had vindicated, so is it the APC? This is confusing. Is it not the APC that have to take it to the Supreme Court now? Because if the Court of Appeal have vindicated you in this judgment based on the certified true copy, Is it at the APC that will go to court of the Supreme Court? What's going to happen? I mean, I don't get it. Or where will, because you said there's also a threshold. What will happen?
Well,
I can see you're laughing.
As I said earlier,
you're laughing big time.
Yes. It's because, Rufai, you see, it's laughable. If you do not want to cry, you laugh. People have been complaining. A lot of us spoke against people who kept saying that they're losing confidence in the judiciary. And then you get this farce. It's a joke. You have to laugh about it. If not, it would be so sad. So back to your question, though, that would depend on the legal team, both for the party and for the candidate. They would probably sit down and decide what there is to take to the Supreme Court. And I guess that even the legal team of the APC would be embarrassed by what they've seen and would also want to file something before the Supreme Court as well, just in case. So I think that we'll get the Supreme Court looking at the entire thing from the word go. The issues there, membership, is it an internal process, etc., etc., and we'll go as far as looking at the almost magical removal of 165,000 votes as well, because the Court of Appeal, of course, did whatever sort of job they did. They didn't even go to that, which was what came up from the tribunal in the first place. They didn't even go to that. They just hinged it on the fact that they felt he wasn't a member, therefore, end of appeal. So I think the Supreme Court is going to have a holistic approach to the matter, and they need to, because the judiciary is on trial here from the court of public opinion. And some people say, oh, what matters is the judiciary. Yes, but what matters, really, what matters is the millions and millions of people who have voted, or who turned out to vote, and who are crying and hurting that the mandate they gave freely to someone is being tampered with. And in this vein, I have to thank President Obasanjo. I have to thank Chief Falana and also Senator Shehu Sani, because I've seen their comments on these things. And these are the comments that get people thinking. Ordinarily, if we speak, they say, oh, he's a politician, what is he saying? But it is good that these people have spoken, who are not members of the NMPP, who want justice and who want this country to move forward. Because you cannot move the country forward if we have things like this in the judiciary.
Ladeko Johnson, for the benefit of our viewers and others who may not have read the judgment, I've taken another look at it. What the tribunal decided was that they sacked Abba Yusuf of the NMPP as governor, because they said 165,000 plus ballot papers were not duly stamped by INEC, rendering those votes invalid. And through their arithmetics, they arrived at the decision that Gawuna should be the person to be given the certificate of return. Now, what this Court of Appeal did is to affirm that judgment. Because again, if you look at Justice Adumain's ruling, he says, I find no merit in this appeal, which is liable to be and is hereby dismissed. In other words, the case that Governor Abba Yusuf took to the Court of Appeal was dismissed. Sanga JCA also dismissed the appeal. Lateef Ganiyu, JCA, also dismissed the appeal. So the three justices on the panel, they were unanimous in dismissing the appeal. So this contradiction that we're talking about, I really don't see it. I've taken time to look again at this, at the holding in this particular case. Second,
Dr.
is the issue, just wait. Second is the issue of qualification.
Yeah.
Now, the Court of Appeal said that Governor Abba Yusuf should have in fact been disqualified
By the tribunal.
by the tribunal.
Yeah.
And that the tribunal erred by not addressing that matter. And they spent a lot of time, showing how the tribunal arrived at its decision in error, par incuriam, as lawyers will say. So really, I don't really see what this contradiction is. What has happened is that Abba Yusuf has lost at the tribunal level, he has lost at the Court of Appeal. But he says that this is a temporary setback. He seems to have so much faith in the Supreme Court that the Supreme Court will set aside the decision of the two lower courts that have decided in favor of the APC.
Thank you, sir. I think at the beginning of the program, you went further to read the concluding part of the lead judgment, which says that it has set aside the judgment of the tribunal. I didn't read it. You read it, sir. And it's before you right there. And then Sanga, I believe, concurred. The other gentleman, the Yoruba judge, now laid the better foundation in, in his own, but they all concurred as to costs. And the cost there was against the APC, the first respondent. So you see that no matter how we try to put it, I see that you're trying to do your work and you're trying to balance both ends. No matter how we look at it, there is a contradiction there. And so there's work for the Supreme Court to do.
Okay.
And yes, Abba Yusuf has hope and belief in the Nigerian judicial system. And that is why he's taken pains. Himself, the party, Senator Kwankwaso, they've taken pains to keep talking to the people of Kanu, say, please just remain calm. Because the people feel they have been cheated. And God, I won't say more than that.
So let's come in here.
They feel they have been cheated and we call for justice.
So let's deal with facts. Let's come in here. If you read from page 50 of the document, it talks about qualification. Talks about section 177 of the Constitution of Federal Republic of Nigeria. It says the person shall be qualified for election to office of governor if he's a citizen of the country, is attained age of 35 years, member of a political party, and is sponsored by the political party. And he went ahead, to prove the logic behind it. In one of the parts, it did talk about, the point made by the tribunal, and also talking about the fact that as the tribunal stated, the NNPP was not able to sufficiently prove its case that Abba Yusuf was indeed qualified for that election by being on that electoral list. And it goes on and on from that 57 to about 72, the final part, saying everything about the case before it now made its own, assumption in the last side. It says, okay, they know the truth about the matter and all of that. So if you look at it, there's a clear case there that the issue of qualification was resolved. And what this is saying in this judgment, that the issue of qualification, your appeal of issue of qualification was dismissed. Because if you read from page 50 to about 66, where it now further says that, that from the facts of the case, I'm tempted to say within the collective conscience of the appellant and the third respondent that they know the truth of the matter, and I'm reminded of those indelible evergreen words credited Ottoman Dafojo, like I've read before. He also said here that, therefore, they are judged failure by the appellant and the third respondent to comply with the provisions of section 177C of the Constitution, Federal Republic of Nigeria as amended, is fatal to their election. A person must first be a member of a political party before he can be legally or validly sponsored by the party as a candidate for general election, where a political party carelessly sponsors a person who is not its member of candidate for the election, such an act of sponsorship like a court or tribunal who undertakes the exercise to jurisdiction which does not have or possess anything is but a nullity, irrespective of whether such a person performs excellently well in the question election. Sponsorship without membership is like putting something on nothing. It cannot stand on nothing. The applicable legal term is ex nihilo fit.
Ex nihilo fit.
Which means from nothing comes nothing. The third respondent shot herself in the foot by undertaking to sponsor the appellant before fishing for the membership of the party after the election. By the way, this is a subtle reminder to our political actors and players that it's a clear case of a political party or some of its members acting with brazen, impervious impunity as if the Constitution of the Federal Republic of Nigeria is not binding by a present person or a candidate for a serious general election by its own members. You know, and it further says that, and are the same political party or members wherefore accuse the judiciary of sundry wrongdoing. So what it has said, it has cleared the matter on qualification here. But the discrepancy, like you're saying, it now further says that I will conclude by stating that the life issued in this appeal are hereby resolved in favor of the first respondent, which is the APC, and against the appellant you. But I don't understand this phrase that now says, in the circumstances I resolve all the issues in favor of the appellant against the first respondent. This is confusing.
And then the final conclusion. And then the final conclusion.
Voila! The judgment of the tribunal.
Can hear you.
The verdict of the tribunal between EPTK and Governor blah 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 blah. Oh, my phone just ceased. Goodness me, this is crazy.
Has been set aside. Is hereby set aside.
Is hereby set aside.
All the page 57, page whatever. We say, how is it that in your certified true copy, signed by the judge or by the judges, you have that conclusion? How? Were there two different judgments typed and prepared? That is the issue. Leave the facts and the law to the Supreme Court. What we're saying is that the optics are bad, and you cannot stop anyone right now from saying that they have no confidence in the judiciary.
Okay.
It is not a joke. I'm not saying you're joking about it. Yeah, the facts and the law will be settled in the Supreme Court.
Ladipo Johnson.
When the Court of Appeal
Ladipo Johnson
comes out with that, then you begin to know that in this modern day of computer-produced documents, something must have been there. Was it cancelled? Was part of it removed? Are they going to tell us it's a clerical error? They cannot say that. There's what we call the slip rule in law, where you can recall your judgment if there's a small error. This is not a small error.
Well, Ladipo Johnson.
It isn't. It doesn't fall within the slip rule.
Okay, hold on.
So it is for the Court of Appeal to let Nigerians know how that happened and how they couldn't get us a CTC for about 4 or 5 days. No one is a fool.
Okay.
We might be members of the bar, we might be cautious in what we say, but I tell you, the people out there, the millions of people out there who now believe that they have been cheated, they are not Ladipo Johnson and they are not Rabiu Musa Konkoso.
Ladipo Johnson.
And that isn't a threat.
All these details will be resolved by the Apex Court. So nobody can make any final statements.
Yes, thank you.
And not certainly people who have not read, even the judgment that is that has now been put out there. We can't be cherry picking. But let me ask you, can a man who is not a candidate of a political party stand for election in Nigeria? And whose name is not on the register of a political party?
A man who is not the candidate of a political party.
Who is not a member of a political party.
A man who is not a member of a political party cannot stand for election. How do you become a member of a political party? There are several things. A man who is not a member, can he have a membership card? These are all questions, as I say, for the lawyers. Yes, I'm a lawyer. For the lawyers at the tribunal, at the Supreme Court now, they're going to treat these issues. And maybe, maybe they're sub judice. You understand? But basically, yes, you are right. If you are not a member and you are not sponsored by the party, you cannot contest. That's right.
Okay.
But if you are a member, if the party says you are a member, and it says this is his membership card, if you have, registered, and maybe one didn't have his name, one had his name, there are issues there.
Okay, well.
And these are things that you have to look at the records of the tribunal and have to be done properly at the Supreme Court. That's why I say I expect that the Supreme Court will look at the entire thing holistically.
Well, the court,
as you well have said.
The Court of Appeal was very clear, though, that a political party is not above the Constitution of Nigeria. It's not above the laws.
No, neither is the judiciary above the Constitution or the law. The judiciary are not above the Constitution or the law.
Okay.
And neither is INEC.
Okay.
No one is above the Constitution.
Very good. On that
and we
note,
hope that Nigerians realize that.